All right, welcome. I am back with another James Comey update video. By now, you probably know that the case was dismissed. It was dismissed in the way that we had talked about on this show, and specifically in a video that I put out over the weekend. And what I would like to do today is go through the judge's order that dismisses the case, and then we'll talk about whether or not it can be appealed, whether the appeal might succeed, whether the case can be refiled, and just overall go for an angle of trying to understand what just happened in the case. I think we got a pretty good idea because we've been tracking the case since the day it was brought, reading every filing, and we knew that this was a strong possibility going into this week. In fact, I specifically said the case could be dead before Thanksgiving, and that's what happened. Speaking of Thanksgiving, happy Thanksgiving to all of you. I do have some videos lined up to release during this week. There are clips from my most recent podcast episode, but I'm going to try and enjoy the Thanksgiving holiday with the family and not be deep into the material I usually cover and try and take a break because been at it pretty hard recently, and I really enjoyed it. And I'm a bit sad the James Comey case is dismissed, although I don't think it's over. It's not all completely over, and the topic isn't completely gone. But I would have liked to have seen it continue some more because I think it would have been quite fun to go to trial. Thanksgiving is my favorite holiday of the entire year. It's the one I look the most forward to, and yeah, it's a holiday that I have some reflections on, which, well, I'll go ahead and say it here at the beginning of the video. So I really like the I believe it's Cicero. I believe it's Cicero. It's one of the Stoics. The quote is gratitude is not only the greatest of all virtues, but the parent of all others. And one of the things I really like about Thanksgiving is it calls us to engage in that sort of virtuous thought and behavior and to express gratitude for all the things that we are thankful for or that we should turn our mind towards and be thankful for. Most of all, thankfulness to God, but then also thankfulness to everybody that's around us, our friends and our family, all that we have, our life experiences, and the days that we have ahead of us, the memories that we've made, being thankful for your struggles and also how you overcome those struggles. So I think Thanksgiving is a unique holiday in that it calls us to be better people, to be better humans. And I always find it to be a bit of a rejuvenating holiday, a sentimental holiday. And I wish you all a very happy Thanksgiving. And I want to take just this moment at the beginning of this episode to express my thankfulness to you for all the things you do to support what I do here at this show. Watching the videos, liking, sharing, commenting, supporting me in whatever way that you choose to. It all counts for something. And if it wasn't for you guys showing that support, encouraging me, and then contributing to what I do here, well, I wouldn't be able to do it. It wouldn't make any sense. I would occasionally maybe be able to make an article or write a thread, but I would have to go get a regular job and keep all my ideas to myself and all my document nerding to myself, So it's you guys who make this possible and have put me here behind this microphone. And I'm really thankful. I'm very thankful to each of you. So I wish you a happy Thanksgiving, and let's get to the documents. So, as I said, you can thank you to everybody who supports me. You can find links to support me in my link tree. You can also find all the places to follow, all the places to watch, all the places to listen. So I have recently added a thread section to there. It's right here, Just Humans Threads, so that if you're not on X, you can still read the threads that I write over there. This is the video that I already did over the weekend, 2 major threats to the case against James Comey. And the very first threat I talk about in the first 30 minutes of the episode is the threat that took out the case, that got it dismissed. Not the first time I talked about it. I raised it the day it was filed, back on October 20th, the day that motion to dismiss was filed. And we've gone over that motion, and we went over the US's response to that motion. You can also find that same video on Rumble, and I uploaded it to X as well, and it's on YouTube also, right there. On YouTube, the thumbnail looks a bit different. Same title, 2 major threats to the case against James Comey. Okay. Let's go to our docket. It won't be the last time, but I gotta say, it feels a little bit different going to the docket now that we know it's dismissed. Next filing we'll be watching for is an appeal being filed. So this is the order right here. And I don't really feel like giving a ton of background on this. I assume that if you're watching this, you're familiar with the case, and you've probably have watched my videos before, and I've talked to you about the different judges that are involved in the case, and the motions and all that stuff. So if you haven't, then go back and watch that video I made. Watch the first 30 minutes of the 2 major threats video, and you'll be caught up. Okay, I want to get this. That'll be better. That'd be better. Okay, opinion and order granting motion to dismiss, which is document number 60. Oh, one more thing. As I go through this, I've already read a little over half of it. As I go through this, I'm going to skip over the citation she makes. The judge makes a lot of citations to other cases and statutes and all sorts of things, and which is very good. It's very good that she does that, but it just kind of like messes up the flow of me reading it if I'm constantly citing what she's citing there. So I'm going to skip over most of those things, or at least when it makes it kind of clunky in the presentation, I'm going to skip over it. Hey, Hercules, are you ready? You ready for this? All right. You ready to go? Yep. We're going to get into some documents. Here we go. You making your appearance? Hold up, hold up, hold up. There you go. Come here. You're on screen. You're on screen. Say hi. You want to say hi? Oh, you shy? You shy? Oh, okay. Okay. Can you speak? Oh, yeah. Speak again. Nope, he's done. That's all he wanted to say. Oh, you're back. Do you have something to say? Okay. On September 25th, 2025, Lindsay Halligan, a former White House aide with no prior prosecutorial experience, appeared before a federal grand jury in Eastern District of Virginia. Having been appointed interim U.S. attorney by the Attorney General just days before, Ms. Halligan secured a 2-count indictment against former FBI Director James Comey with making false statements to Congress and obstructing a congressional proceeding. Mr. Comey now moves to dismiss the indictment on the ground that Ms. Halligan, the sole prosecutor who presented the case to the grand jury, that's a big, big deal that she is the only person who presented it and the only person who signed it, was unlawfully appointed in violation of 28 U.S.C. 546. That's the statute she was originally appointed under, I believe, and the Constitution's Appointments Clause. In fact, I'm going to grab her appointment order real quick because that's going to be useful to us. Okay, here it is. 28 U.S.C. 546 is the only statute under which Halligan was originally appointed. As explained below, I agree with Mr. Comey that the Attorney General's attempt to install Ms. Halligan as interim U.S. Attorney for the Eastern District of Virginia was invalid. And because Ms. Halligan had no lawful authority to present the indictment, I will grant Mr. Comey's motion to dismiss the indictment without prejudice. Now, a lot of folks are making a big deal about, oh, look, it's without prejudice. It's without prejudice. I understand why, but it's not a given that this can be refiled. Of course, it's going to be appealed. I don't think they're going to win on appeal. They don't have a very good chance of it. There's now been 4 or 5 interim U.S. attorneys who have been declared disqualified or invalid because of the way they were appointed, the circumstances around which they were appointed, and the appeals have on those have not been successful. Without prejudice means this case could be filed again. However, the statute of limitations on these charges for the facts that are in this case, even though the facts are actually incorrect, which is a whole other thing to discuss, expired September 30th, 2025. So we're now almost 2 months past, almost 60 days away past when the statute of limitations expired. And since the charging instrument in this case was unlawfully brought by a U.S. attorney whose her appointment has now been declared invalid, meaning she did not at the time have the authority to bring that indictment in the first place, it did not preserve the charges so that they could be brought again. The statute of limitations ran, and this indictment never should have been brought, so I don't believe it can be refiled. There's going to be an argument about it. I'm just telling, it may happen. I'm just telling you, it is not a given at all that the charges can be refiled. And I've seen a lot of people, kind of clinging to this as being, they're going to bring the charge again. It's going to be even better, or superseding indictment or whatever. It's not a given. All right. Legal background. The Appointments Clause prescribes the exclusive means of appointing officers of the United States. The text of the clause contemplates two types of officers, principal and inferior officers. Principal officers must be appointed by the President with the advice and consent of the Senate. The same process is also the default manner of appointment for inferior officers. But the framers recognized that requiring all officers of the federal government to run the gauntlet of presidential nomination and then Senate confirmation would prove administratively unworkable. So on one of the last days of the Constitutional Convention, they authorized an additional and streamlined method of appointment for inferior officers. In the final provisions of the Appointments Clause, that provision, sometimes referred to as the Accepting Clause, permits Congress to, by law, vest the appointment of inferior officers in the President alone, in the courts of law, or in the heads of departments. For United States attorneys, Congress has preserved the constitutional default rule of presidential appointment and Senate confirmation. Congress has also established a mechanism set forth in 28 U.S.C. 546, which is the statute under which Halligan was appointed, for appointing interim U.S. attorneys when a vacancy arises. Section 546 essentially divides the responsibility for making interim appointments between the Attorney General and the district courts. It provides in full. Here is the statute. It is a little bit clunky legalese, so I'm going to read it once through without interruption, and then I'm going to read it again, and I'm going to explain some pieces of it, okay? A. Except as provided in subsection B, the Attorney General may appoint a United States Attorney for the district in which the office of the United States Attorney is vacant. B. The Attorney General may not appoint a United States Attorney, a person to whose appointment by the President to that office the Senate refused to give advice and consent. C. A person appointed as United States Attorney under this section may serve until the earlier of 1. The qualification of United States Attorney for such a district appointed by the President under Section 541 of this title, or 2. The expiration of 120 days after appointment by the Attorney General under this section. D. If an appointment expires under subsection C2, the district court for such a district may appoint a United States Attorney to serve until the vacancy is filled. The order of appointment by the court shall be filed with the clerk of the court. This is 28 U.S.C. 546. All right. Part A says, unless the person has already been rejected by the Senate, meaning the person nominated by the President to be the United States Attorney for that office went through the process and their nomination was rejected by the Senate, unless that has happened to that person, the Attorney General may appoint a United States Attorney for the district in which the office of United States Attorney is vacant. So the Attorney General can appoint a United States attorney to an office that has a vacancy as long as that person has not been rejected by the Senate already. C, a person appointed as United States attorney under this section may serve in that capacity until either 1, the Senate confirms the president's appointment. So if the president nominated somebody, that person then takes over the office and the interim attorney is out, or until the 120 days have expired. If it's C2, it's 120 days have gone by and there hasn't been someone confirmed, then the district court for such a district may appoint a United States attorney to serve until the vacancy is filled. The order of appointment by the court shall be filed with the clerk of the court. So I remember when I first read this statute, which was actually when Jack Smith, with the motion to dismiss Jack Smith for unlawful appointment, and I was iffy on whether Jack Smith, I remember saying I was of two minds about it. On the one hand, he was not a Senate-confirmed attorney, and the special counsel statute for a special counsel's office requires that the special counsel be a United States attorney, has to have Senate confirmation. However, the attorney general absolutely has the power to delegate her authority and empower other attorneys and prosecutors to prosecute cases, to nominate, to assign inferior officers to cases and to districts, and that is within the attorney general's power. So on the one hand, Smith wasn't qualified per the statute to be a special counsel with a special counsel's office and a team and all those things. On the other hand, the AG absolutely has the power to appoint inferior officers and delegate to them the authority to conduct legal proceedings, including prosecutions. So it wasn't clear cut to me. And when this motion was filed to dismiss Halligan for unlawful appointment, I was pretty convinced by it. The Halligan was not lawfully appointed. And I remember saying, if she was lawfully appointed, then you have to reckon with the fact that Jack Smith was too. And that's going to cause some cognitive dissonance for people on the right, who long argued that Jack Smith was unlawfully appointed and all this stuff. And then when he was dismissed by, when the ruling came down from Judge Cannon, they celebrated and talked about how great Judge Cannon was and all these things. And I'm like, I get it, but I just don't think it's as clear cut. I'm just not fully on board. I have some reservations. And when Comey filed this, I remember telling you guys, it was on October 20th, October 21st, around there. We read this filing within a couple days on the show, and I was like, I find that compelling, guys. I think Halligan's unlawfully appointed, and I think this is a kill switch in the case. And then we read the United States filing opposing, and Henry Whitaker, who's a counselor to the AG, I thought his filing was very compelling, and he changed my mind. I was like, my mind's been changed. I think she is lawfully appointed, but that also means Jack Smith was lawfully appointed, and Judge Cannon shouldn't have dismissed those cases against Trump, or the case against Trump. The Docs case was the only one she had dismissed. So again, it's kind of like, it's not really a catch-22 necessarily, but it's something like that. And as I sit here and read this statute to you now, I find myself back in the position of, yeah, she wasn't lawfully appointed. And she wasn't lawfully appointed because it says really, really clearly here that the person appointed to United States Attorney of this section may serve until the earlier of. And what happened in this instance was 120 days expired, and then the district court appointed a U.S. attorney to serve until the vacancy was filled. And we're going to get into it more in this order, but by the plain reading of the language, it doesn't present as the AG gets to make sequential 120-day interim appointments. it doesn't read that way. The way it reads is that the AG can make an interim U.S. attorney appointment to fill that office until 120 days have expired, or someone has finished the Senate confirmation process and been confirmed to be the U.S. attorney. But absent that, the district court appoints a United States attorney to serve and fill the vacancy, which is usually traditionally what they've done. And as far as I'm aware, is they retain that person who was the interim attorney, which is what happened here, or it's the like the first assistant in that office. It's somebody from within that district's office, so that there's continuity within the office and the district. And the whole point of this, it makes so much sense that it's set up this way because it keeps the office running. The whole point of it is so that the U.S. Attorney's office can continue to function, and the district can continue to function, and that serves the ends of justice, both from the point of view of application of the law and pursuing criminals and investigations and trying people, but also from the perspective of the defendant. You don't want to have your case, if you have a case brought against you in that district, you don't want to be waiting for trial or waiting for something to happen in your case so that you can actually defend yourself or make filings and be stalled out because there's nobody who's a U.S. attorney running the office. The whole point of this setup is so that both the prosecutions continue and the defendants are able to continue defending themselves, making motions, and the whole it's just meant to keep it going, and it makes sense. All right, one more thing. I have seen some people mention, and the judge mentions here, the Federal Vacancies Reform Act of 1998. That does not apply here. Halligan's not appointed under that, and it's just not an issue here. But I have seen it come up here occasionally in some posts and comments from people, not on my stuff, but just online. It doesn't apply in this case. All right, factual background. On January 20th, 2025, Jessica Aber, who had been nominated by President Biden and confirmed by the Senate, resigned from her position as U.S. Attorney for the Eastern District of Virginia. The following day, the Attorney General appointed Eric Siebert as interim U.S. Attorney under 28 U.S.C. 546, same statute as Halligan. Mr. Siebert's 120-day interim appointment was set to expire on May 21st. So, on May 9th, 2025, the judges of the district exercised their authority under Section 546D to appoint Siebert to continue his role, effective May 21st. So right here, this part. On September 19th, 2025, Mr. Siebert informed colleagues of his resignation. According to news reports, Mr. Siebert had recently expressed concerns to senior Department of Justice officials about the viability of pursuing charges against Mr. Comey and New York Attorney General Letitia James. Mr. Siebert's resignation came hours after President Trump told reporters at the White House that he, quote, wanted Siebert out. The next day, President Trump posted and later deleted one of the most cringy and hilarious and just Trumpian messages ever. She didn't say all that on social media. Pam, I have reviewed over 30 statements and posts saying that essentially same old story as last time, all talk, no action. Nothing is being done. What about Comey, Adam Shifty Schiff, Letitia? They're all guilty as hell, but nothing is going to be done. Then we almost put in a Democrat-supported U.S. attorney in Virginia with a really bad Republican past, a woke rhino who was never going to do his job. That's why two of the worst Dem senators pushed him so hard. He even lied to the media and said he quit and that we had no case. No, I fired him, and there is a great case, and many lawyers and legal pundits say so. Lindsay Halligan is a really good lawyer and likes you a lot. We can't delay any longer. It's killing our reputation and credibility. They impeached me twice, indicted me 5 times over nothing. Justice must be served now. President DJT. Oh, God. I love him. And I also, sometimes I just want to put my head in my hands and say, Trump, what are you doing? Less than 48 hours after President Trump's post on September 22nd, 2025, the Attorney General issued an order authorizing Lindsay Halligan to be the interim United States Attorney for the Eastern District of Virginia during the vacancy in that office. That's this order. The September 22nd order cites only 28 U.S.C. 546 as the basis for Ms. Halligan's appointment, if only it had used a different statute. On September 25th, 2025, a grand jury sitting in the Eastern District of Virginia returned a 2-count indictment against Mr. Comey, charging him with making false statements within the jurisdiction of the legislative branch in violation of 18 U.S.C. 1001A2 and obstructing a congressional proceeding in violation of 18 U.S.C. 1505. The charges stem from testimony Mr. Comey gave during a Senate Judiciary Committee hearing in 2020. Ms. Halligan was the only prosecutor who participated in the government's presentation to the grand jury, and only her signature appears on the indictment. This is critical. The norm, according to everything I've read and researched here, the norm is for a prosecutor in the U.S. Attorney's Office to present and sign the indictment, and for the U.S. Attorney for that office to also sign. So 2 signatures, the top U.S. Attorney for the office and then a line prosecutor. That didn't happen here. Only Halligan presented and signed the indictment, which means if Halligan's appointment is deemed invalid, which it has been, the indictment is invalid because she never had the authority to bring it in the first place. If another line prosecutor, any prosecutor in that office, any of them, had also signed the indictment, and that person was lawfully employed as a prosecutor in that office, the Comey indictment would be intact. The case would be intact. It would go forward. Halligan would still be invalid. She'd still be disqualified. But because a lawfully authorized, empowered prosecutor in that office had signed the indictment too, the indictment would stand. Procedural history. On October 20th, 2025, Mr. Comey moved to dismiss the indictment on the ground that Ms. Halligan's appointment was unlawful under Section 546 and violated the Appointments Clause. On October 21st, the Chief Judge of the 4th District designated me to consider this and any other motion concerning the appointment, qualification, and disqualification of the United States Attorney or the United States Attorney's Office in Eastern District of Virginia. This has to happen because it's a challenge to a U.S. Attorney who is over that district. And so in the name of avoiding conflict of interest, any complaints of ethics or anything like that, the challenge has to be heard by an out-of-district judge, because the judges in this district are Eastern District of Virginia judges who work with Eastern District of Virginia cases brought by the Eastern District of Virginia U.S. Attorney's Office. So it's better for all involved for an out-of-district judge to be brought in to hear a challenge to that appointment. There's precedent for this in case law and all that stuff. So, footnote. The grand jury was originally presented with a 3-count indictment. At some point, however, a second 2-count indictment was prepared. It is still unclear by whom, despite like 8 filings, supposedly clarifying the record, correcting the record, affidavits from Halligan, all these things, transcripts. It is still unclear exactly how every minute of the grand jury proceeding went down. It's almost like the person running the grand jury had never prosecuted a case before, let alone run a grand jury. Both indictments were signed by Ms. Halligan and the grand jury foreperson and were returned to the magistrate judge. During the indictment return proceeding, the foreperson explained that the grand jury did not agree on the very first count, and that counts 2 and 3, which, by the way, there is no count 3. In fact, I'm going to show you. Here are the indictments, the failed one and the one that passed. Here's the failed one. Here's where they made the correction. Count 1 only. You go and look right here. count 1, count 2, count 2. There is no count 3. And if you also look at the signature and the stamp on the count 2 in each one of these indictments, the one that is true bill and the one that's not, you can see that the signature and stamp are the exact same, as are the errors. And see where you can see a little bit of the grand jury foreperson signature. See those little marks below the line right there? If you go and look right here, they're the exact same. You look at Halligan's signature, look at that. It's the same. Meaning that this exact same signature was attached to both. And the way these little marks appear under the line, their placement is the exact same. Like the mark where the pen lifts up just a little bit as it goes over the word foreperson, it goes over the letter F. The mark up here that goes through the U is the exact same. There's a little bit of a difference here because where it's redacted, that person's name is redacted here, right? They whited it out. So the whiteout or the redaction was applied 2 different times because there's 2 different pieces of paper, but you can tell this is a photocopy. This is the exact same signature of Halligan and the exact same signature of the foreperson. There's no way the foreperson signed the true bill twice and managed to mark through the U of true and the F of foreperson in the exact same way. The exact same way. There's no way they managed to sign their name and leave just these little bitty lines and this half a loop right here on both in the exact same places. There's no way. And there's no way Halligan left a signature like this that was pixel for pixel the exact same. So her signature, she says in the record that she tells the judge, in the magistrate hearing when the grand jury returned the indictment, she tells the judge she didn't sign the 3 count. And yet the judge tells her in the transcript, well, I'm holding a 3 count version that has her signature on it. And she's like, I don't know where you got that. I don't know where it came from. I didn't sign it. Just weird, man. And then there's 2 count 2s. Because instead of having the count, I'm guessing because there should be a count 3 here, but instead they lifted this right here. They just copied this and attached it. I don't know, man. It's just one of many oddities or irregularities in the grand jury proceeding in this case, which justified grand jury disclosure, but that's a separate issue. Okay. Finding it necessary to determine the extent of Ms. Halligan's involvement in the grand jury proceedings, I, Judge Currie, ordered the government on October 28th to submit for in-camera review all documents relating to Ms. Halligan's participation before the grand jury, along with complete grand jury transcripts. We're about to find more irregularities. Actually, there's one we didn't know about until now. Upon reviewing the transcript provided by the government, I determined it did not include any remarks made by Ms. Halligan before and after the testimony of the sole witness. You guys remember who the sole witness to the grand jury was? The lead FBI case agent who was tainted by attorney-client privilege material that he never should have had access. He never should have seen it. And he's the only witness to this grand jury. And then after he testifies, the Office of Legal Counsel pulls him off the case because he's been exposed to evidence he never should have been exposed to because it was attorney-client privilege. Weird how that happened. And by weird, I mean wrong. And then the fact that there's no remarks on the record from Ms. Halligan before or after he meets with the grand jury. Accordingly, on November 4th, I directed the government to submit a complete transcript and or recording of all statements made by Ms. Halligan to the grand jury on September 25th, 2025. In notice of compliance filed on November 5th, the government represented it had produced all materials requested by the October 28th and November 4th orders. So that's twice that the judge has gone to Halligan's office and said, give me all the materials relevant to or related to the grand jury proceeding in this case. In response to the October 28th order, the government provided the transcript of the grand jury proceedings that was previously provided to the government by the transcription service. The court's subsequent November 4th order additionally requested the recording from the grand jury presentation. Upon receiving this order, the government immediately contacted the transcription service and requested the complete recording. Further, the government requested that the transcription service transcribe the entire recording, which had not been done previously. This new transcript was provided to the government on November 5th, 2025. The above items have now been provided to the court in compliance with the court's order. That's what their notice of compliance said. On November 3rd, the government responded in opposition to Mr. Comey's motion. That's the order that I read to you guys and found very compelling. And I thought, hey, Halligan may be lawfully appointed, and that means so is Jack Smith. Good filing. And I still maintain it's a good filing. It was very compelling, which is what it needs to be. And changed my mind on the issue. I've now changed back. I'm allowed to do that. So are you. That's kind of the whole point of this thing. Each side makes arguments, and you consider their arguments. And you weigh them, and you decide which one makes the most sense. And it's okay to go back and forth on it. That's part of the process. There's going to be an appeal, and it could be that the appeal of this order changes my mind again. Like it does, it just like it overcomes, but we'll see. On November 3rd, the government responded in opposition to Mr. Comey's motion. Also that day, the government filed an order from the Attorney General dated October 31st, 2025. The October 31st order reads in its entirety, on September 22nd, this is from AG, you guys may remember. On September 22nd, 2025, I, AG Bondi, exercised the authority vested in the Attorney General by 28 U.S.C. 546 to designate and appoint Lindsay Halligan as the United States Attorney for the Eastern District of Virginia. For the avoidance of doubt as to the validity of that appointment, and by virtue of the authority vested in the Attorney General by law, including 28 U.S.C. 509, 510, and 515, I hereby appoint Ms. Halligan to the additional position of Special Attorney as of September 22nd, 2025. Well, that would be retroactive. Can the Attorney General appoint someone retroactively to a position and empower them with new statutes 6 weeks after the fact? I'm not so sure about that, guys. And thereby ratify her employment as an attorney of the Department of Justice from that date going forward. As Special Attorney, Ms. Halligan has authority to conduct in the Eastern District of Virginia any kind of legal proceeding, civil or criminal, including grand jury proceedings and proceedings before the United States magistrates and judges. In the alternative, should a court conclude that Ms. Halligan's authority as Special Attorney is limited to particular matters, I hereby delegate to Ms. Halligan authority as Special Attorney to conduct and supervise the prosecutions in United States v. Comey and United States v. James. In addition, based on my review of the grand jury proceedings in United States v. Comey and United States v. James, I hereby exercise the authority vested in the Attorney General by law, including 28 U.S.C. 509, 510, and 518b, to ratify Ms. Halligan's actions before the grand jury and her signature on the indictments returned by the grand jury in each case. Well, Mr. Comey filed his reply on November 10th. On November 13th, I heard oral arguments from the parties and took the matters under advisement. During the hearing, I raised concerns about the Attorney General's ability to review Ms. Halligan's presentations to the grand jury when, as of October 31st, the government had not yet received the complete transcription of the service. Oopsie. How did AG Bondi review the record of the grand jury proceeding if the complete transcript of the proceeding had not yet been done and transmitted to the government. I also noted that based on my in-camera review of the grand jury materials, there appeared to be a gap in the grand jury transcript from 4:28 p.m. to 6:47 p.m. when the indictment was returned to the magistrate judge. It was returned at 6:47 p.m. The day after the hearing on November 14th, the government filed an unsworn declaration from Ms. Halligan. I actually missed that fact that the declaration from Halligan was unsworn. And a new ratification order from the Attorney General. Ms. Halligan declared, quote, that the grand jury transcript accurately reflects the full extent of her appearance before the grand jury and explained that the period in question consisted solely of the grand jury's private deliberations. She further stated that there was no additional presentation, interaction, or discussion with the grand jury outside of what is reflected in the transcript. For her part, the Attorney General stated she had reviewed the entirety of the record now available to the government and again ratified Ms. Halligan's actions before the grand jury and her signature on the indictment. Discussion. Oh, by the way, in a motion filed November 21st, which I haven't read on this show, Mr. Comey argues the case should be dismissed because the operative two-count indictment was never presented to the full grand jury. That is true. According to all the grand jury materials that have been presented by the government, there are like 8 filings, I think there have been. I really do. I really think it's 8 filings the government has made to try and clarify and correct the record as to what happened with the grand jury in this case, which is just bizarre that it's taken that much effort. Among the Comey's team has said, look, it's true. It's true. The two-count indictment was never presented. Those 2 counts were presented to the grand jury, and the grand jury apparently did vote to indict Comey on those 2 specific counts. But the 2-count indictment itself was never presented to the grand jury. And there's just weirdness. Now, as I went over in a different episode, the U.S. attorney, when they get a mixed indictment back, so there's multiple charges and there's a mixed return, the grand jury voted to indict or find probable cause to indict on some counts, but not on others. It's a mixed return. It's not unusual for that to lead to an indictment on the ones that were returned. What is unusual is the way it occurs in the record, with Halligan saying she never saw the 3-count version and she only saw the 2-count version. And then it was never shown to the grand jury. The grand jury foreperson signed off on the 2-count version and did so after the rest of the grand jury had already left for the day. So it's just, there's just weirdness, man. And the fact that the DOJ and Halligan's office have done so many filings and have tried to explain it in so many different ways, and there continues to be questions about it, is not a good sign. To me, it seems like they can't, it seems like it would be very easy to, within 2 filings, spell the whole thing out. And yet they can't do that. And that to me is, let's say it's concerning. All right, resolving Mr. Comey's motion requires me, by the way, it's not, that's that right there, that motion to dismiss for the 2-count indictment never being presented to the full grand jury is not before this judge. She's not handling that. All right. Resolving Mr. Comey's motion requires me to decide whether Ms. Halligan was validly appointed as interim U.S. attorney under Section 546 and the Appointments Clause. If the answer to that question is yes, I need not go any further, and Mr. Comey's motion must be denied. But if the answer is no, and Ms. Halligan had no authority to present Mr. Comey's indictment to the grand jury, then the question becomes what remedy is appropriate. Should the indictment be dismissed? If so, should the dismissal be with or without prejudice? I addressed these issues in turn, beginning with whether Ms. Halligan's appointment was valid under Section 546. According to the government, this case is simple. In its view, the one and only limitation on the Attorney General's authority to appoint interim U.S. attorneys under Section 546 is subsection B, which bars the Attorney General from appointing anyone whom the Senate has refused to confirm. Quote, nothing in the text, it continues, explicitly or implicitly precludes the Attorney General from making multiple interim appointments during vacancy. Thus, the motion from the government concludes, because the Senate has not refused advice and consent to Ms. Halligan, the Attorney General lawfully appointed her as interim U.S. Attorney on September 22nd. Mr. Comey counters that Section 546 limits the total tenure of the Attorney General's interim appointments to 120 days, and therefore precludes any additional appointment by the Attorney General, or actually it says precludes an additional appointment by the Attorney General after the expiration of that 120-day period. Accordingly, he argues, Ms. Halligan's appointment was unlawful because the district court possessed the exclusive authority to appoint an interim U.S. attorney once Mr. Siebert's appointment by the Attorney General expired on May 21st. Mr. Comey has the better reading of the statute. The preeminent canon of statutory interpretation requires courts to presume that the legislature says in a statute that what they say in a statute is what they mean, and it means in a statute what it says there. Let's back up. I'm going to read it again. The preeminent canon of statutory interpretation requires courts to presume that the legislature says in a statute what it means and means in a statute what it says. Thus, my inquiry begins with the statutory text and ends there as well, as long as that text is unambiguous. The plainness or ambiguity of statutory language is determined by reference to the language itself, the specific context in which that language is used, and the broader context of the statute as a whole. 546 is unambiguous. Subsection A begins by authorizing the Attorney General to appoint a United States Attorney for the district in which the office of United States Attorney is vacant. Subsection C2, however, imposes a time limit on appointments made by the Attorney General. It specifies that, quote, a person appointed as United States Attorney under the statute may serve until the expiration of 120 days after appointment by the Attorney General. Subsection D then provides a single option for how subsequent interim appointments may be made. Quote, if an appointment expires under subsection C2, the district court for such district, and only the district court, may appoint a United States Attorney to serve until the vacancy is filled. The text and structure of subsection D, in particular, make clear the appointment power, 1, shifts to the district court after a 120-day period, and 2, does not revert to the Attorney General if a court-appointed U.S. Attorney leaves office before the Senate-confirmed U.S. Attorney is installed. The first word in subsection D, if, introduces a conditional clause that establishes the condition triggering the district court's authority. A conditional clause is an adverbial clause typically introduced by if or unless, establishing the condition in a conditional sentence. Usually, this is a direct condition, indicating that the main clause is dependent on the condition being fulfilled. That condition is met once, quote, an appointment expires under subsection C2. 28 U.S.C. 546D, that's what it says right there, sorry. The indefinite article an points to a non-specific object, thing, or person that is not distinguished from other members of a class. So, the expiration of any single Attorney General appointment satisfies that condition. Thus, if, as here, a court-appointed U.S. Attorney resigns, the district court retains the authority to make another interim appointment because the triggering event, the expiration of an appointment under subsection C2, has already occurred. Finally, the conjunction until in subsection D, its main focus or main clause, defines the duration of the district court's authority. It says until, which literally means the duration, the amount of time, the period is until this thing happens. It lasts from the moment of the condition is first met up to the time that the vacancy is filled by a Senate-confirmed appointee. This reading is reinforced by the negative implication canon, which recognizes that the expression of one thing implies the exclusion of others. By the way, that's from Antonin Scalia and Brian A. Garner in the book Reading the Law, The Interpretation of Legal Text from 2012. To be sure, the Supreme Court has cautioned that, quote, the force of any negative implication depends on context, and that the canon applies only when circumstances support a sensible inference that the term left out must have been meant to be excluded. Here, however, the inference is not just sensible, but overwhelming. Congress assigned the authority to appoint interim U.S. attorneys to different actors in different parts of the same statute. First, to the Attorney General in subsection A, and then to the District Court in subsection D. The omission of the Attorney General in subsection D, when combined with her inclusion in subsection A, is strong evidence Congress did not intend for the Attorney General to retain appointment power beyond 120 days. The absence of any temporal limit in subsection D strikes us as deliberate rather than serendipitous, especially in view of the contrast between adjacent sections of a single statute. Adopting the government's contrary reading would render subsection D insignificant, leaving it to lie dormant in all but the most unlikely situations. A statute, and this is a quote from a different case, a statute ought, upon the whole, to be construed as if it can be prevented. No clause, sentence, or word shall be superfluous, void, or insignificant. Courts must give effect, if possible, to every clause and word of a statute. They can't ignore pieces of it or the implication of these words. Under the government's interpretation, Attorney General appointees can serve indefinitely without Senate confirmation, as long as the Attorney General revisits her interim appointment every 120 days. But if that were correct, the Attorney General could prevent interim appointments from ever expiring under subsection C2, which, in turn, would prevent the District Court from ever exercising its appointment power under subsection D. Such a result would run counter to the principle that courts must avoid interpreting statutes in a way that has the practical effect of rendering a provision entirely superfluous in all but the most unusual circumstances. The government's interpretation also conflicts with Section 546's statutory history. See Snyder v. United States and United States v. Hansen as well. Statutory history is an important part of context, defining statutory history as the enacted lineage of a statute, including prior laws, amendments, codifications, and repeals. From 1986 to 2006, Section 546 was identical to its current form. And we've gone over this before, how there was a change in 2006, and then they were like, oh, whoa, we totally screwed that up, and they had to go fix it. Also, she quotes Alito here and Scalia again. I'm going to skip it because I want to get to here. In 2006, Congress amended the statute to abolish the 120-day limit and the district court's backstopping role altogether. This change, which was inserted quietly into the conference report on the Reauthorization Act without debate, made it possible for the United States attorneys appointed on an interim basis to serve indefinitely without Senate confirmation. So 120-day limit, gone. The switch to an unlimited appointment was short-lived, however. Just over a year later, Congress reverted to the Pre-Authorization Act language, reinstating the 120-day limit and the district court's role in the interim appointment process. When Congress amends legislation, courts must presume it intends the change to have real and substantial effect. That's Ross v. Blake, 2016. Yet, if the government's reading were correct, the 2007 Act would have had virtually no effect, as it would still allow the executive to evade the Senate confirmation process indefinitely by stacking successive 120-day appointments. I got to pause and comment on this specific thing. And also pause to sip my coffee. So one of the things that stood out to me in the government's motion defending the appointment of Halligan, one of the things I found compelling was when it went over this change. And one of the things I thought about, or one of the things it conveyed to me, or that I understood from Henry Whitaker's filing and opposing and like shoring up the appointment of Halligan, is it's totally lawful. In his telling and the way he characterizes the 2006 event and 2007 Act, I didn't get this understanding of it on my first read. And then later with my read with you guys. But to take the government's reading here, like she says, if we accept the government's argument and their telling of what happened in 2007, when they corrected this change, this short-lived change that happened in 2006, when where was it? Where they amended the statute to abolish the 120-day limit. Okay, so Congress abolished that 120-day limit in the reauthorization. There we go. It's the USA Patriot Improvement and Reauthorization Act. All right. So the change, which was inserted quietly, and there wasn't a conference on it, and there was no debate over it. It made it that the interim appointments could serve indefinitely without Senate confirmation. Okay. And then they went back on it. They were like, nope, that's not workable. And in 2007, they corrected that specific thing. Well, what would be the point of correcting it if it then meant that they could just stack the successives, they could just do sequential 120-day appointments? What would be the point? Like Congress coming back in and saying, nope, the 120-day limit is back. We're reverting back to the text as it previously was decades before, the way it's been. We've made an error. What would be the purpose of of Congress doing that unless it was to prevent successive sequential 120-day appointments? And that's something that the government's argument kind of like rushed past. Okay? Like they explained what happened there, and then they went on to give examples of what were apparently successive appointments. And I think it was very clever. I think it was like, I'm not accusing it of being like dishonest or anything, but it just kind of rushed past what now seems pretty obvious, that what would be the purpose of Congress making that change and revising the statute back to the way it was if it didn't have in its mind that it wanted there to be 120-day appointments and for that to have a meaning, for that to have a consequence? What would be the point of doing that if we're still supposed to infer that there can still be successive or stacking or sequential 120-day appointments? If that can still be the case, if the government can still do sequential interim U.S. attorney appointments, then Congress might as well have left the Reauthorization Act alone and allowed for interim U.S. attorneys to serve indefinitely. Does that make sense? You get what I'm saying? Like, it would be meaningless if we interpreted it this way, the way that Whitaker, the way that DOJ is trying to argue it should be interpreted. then this reauthorization act that Congress went through and the correction they made in 2007 to it, the correction was Preserving United States Attorney Independence Act of 2007, which reverted back to the exact same language the statute 546 used to have. The act would be meaningless if we still interpreted it as allowing the AG to appoint interim attorneys to serve indefinitely, or by stacking them or making sequential interim appointments. And it would also mean that subsection D, the part where it brings in the district court after the 120 days has expired, it would make that meaningless or useless. What would ever be the circumstances under which that came in? Okay. Undeterred, the government insists that in reenacting the pre-2006 text, Congress presumptively ratified the executive's long-standing use of successive 120-day appointments under the 1986 to 2006 version of the statute. True, a systematic, unbroken executive practice, long pursued to the knowledge of Congress and never before questioned, can raise a presumption that the action had been taken in pursuance of its consent. The long-standing practice of government can inform our determination of what the law is, but the evidence on which the government relies, which I found compelling, is only a handful of successive 120-day appointments across Clinton and Bush administrations. That hardly establishes a long-standing executive practice. Given the fact that the practice goes back over 200 years of presidents appointing and the AG making interim appointments, and the interim appointments being there until there's a Senate confirmation or a district appoints someone to serve in that capacity. The real history goes back 200 years, yet they only have a couple of examples from the 90s and early 2000s. Given the fact that the practice goes back over 200 years and has received congressional acquiescence throughout its history, the conclusion that the president's control of foreign relations includes the settlement of claims is indisputable. This is especially true when considering the Attorney General had no authority to appoint interim U.S. attorneys at all before 1986. Finally, for those who find it relevant, the legislative history confirms Congress sought to eliminate the executive branch's ability to circumvent the Senate's advice and consent role through repeat or indefinite interim appointments. For example, in describing the 2006 framework, Senator Leahy explained Congress had carefully circumscribed the Attorney General's authority to appoint an interim U.S. attorney by limiting it to 120 days, after which the district court would make any further interim appointments needed. The 2007 Act, he stated, would reinstate those vital limits on the Attorney General's authority and bring back incentives for an administration to fill vacancies with Senate confirmable nominees. Notably, Senator Leahy also rejected the notion that the Attorney General could use the 120-day appointment authority more than once, stating that the statute is not designed or intended to be used repeatedly for the same vacancy. And by the way, if the statute was designed so that the authority would go back to the AG, I'm going back up in the filing to where the statute is. If it was designed so that the authority would go back to the AG to make an appointment, it would say so. It would say so. It does not say that. Instead, it says if an appointment expires after 120 days, the district court for such a district may appoint a United States attorney to serve until the vacancy is filled. It doesn't say, or the AG may, or the AG will make another appointment, or the district court may appoint a United States attorney until the AG appoints an interim attorney to fill the spot. Nope. It doesn't mention the AG at all. It says after 120 days, after an interim U.S. attorney has served 120 days, and there is not in a Senate confirmed person to take the office, the district court for such a district may appoint a United States attorney to serve until the vacancy is filled. What fills the vacancy? A Senate confirmed nominee. That is the plain, unambiguous reading of the statute. Senator Feinstein, the 2007 Act's who was the 2007 Act's primary sponsor, similarly stated that the legislation would return the law to what it was before the change was made in March of 2006. She explained it would still give the Attorney General the authority to appoint interim U.S. attorneys, but it would limit that authority to 120 days. If after that time the president had not nominated a new U.S. attorney or the Senate had not confirmed a nominee, then the district courts would appoint an interim U.S. attorney. By the way, I fully understand that she's quoting Democrat senators, and that some of you may say, oh no, Senator Leahy, oh no, Senator Feinstein. Guys, I join you in the cringe. I join you in that. Like, ugh, Senator Feinstein. But guess what? It doesn't matter. It doesn't matter what we think of these individuals. What does matter is that they're the ones who passed the statute. They're the ones who passed the statute. And their words about what they mean for the statute to do, the effect they intend for the statute they passed to have, that's what matters. It doesn't matter what letter is by their name, what their names are, what other things we know about them, what we think about them, love them, hate them. It doesn't matter. What matters is what the statute says and what the statute is intended to do. Let's see. Several other senators echoed this statement, as did members of the House of Representatives. And the accompanying House report explicitly identified bypassing the requirement of senatorial advice and consent as a primary concern motivating the 2007 Act, which reverted the change back to the way it had been. In sum, the text, structure, and history of Section 546 point to one conclusion. The Attorney General's authority to appoint an interim U.S. attorney lasts for a total of 120 days from the date she first invokes Section 546 after the departure of a Senate-confirmed U.S. attorney. If the position remains vacant at the end of a 120-day period, the exclusive authority to make future interim appointments under the statute shifts to the district court, where it remains until the president's nominee is confirmed by the Senate. Ms. Halligan has not appointed in a manner consistent with this. She was not appointed in a manner consistent with this framework. Clearly, the 120-day clock began running when Mr. Siebert's appointment on January 21st, 2025. When that clock expired on May 21st, 2025, so did too the Attorney General's appointment authority. Consequently, I conclude that the Attorney General's attempt to install Ms. Halligan as interim U.S. Attorney for the Eastern District of Virginia was invalid, and that Ms. Halligan has been unlawfully serving in that role since September 22nd, 2025. Now, now that we've read this, okay, I shouldn't say I don't. Now that we've read this far, now that we've looked at this, doesn't this make sense? Like, doesn't this plainly just make good sense? There's no need to say this judge is crooked, this judge is deep state, Comey's friends are bailing him out, AG Bondi sabotaged the case, like whatever. Man, like all of these reactionary takes that have the same energy as I got a bad grade because the teacher doesn't like me. Like that's what I hear when I read or listen to people who have these reactionary takes that blame reasonable orders and reasonable actions by a court that are understandable, that people can make reasonable arguments about. Like, as I said, both filings on this issue, filings from Comey's side and filings from Halligan's side, have both made sense to me and both have sounded compelling. The arguments are reasonable. And the judge's order here cuts through the I want to say it cuts through how each side is advocating for their client, which on one side the client is the United States government, and on the other side the client is James Comey, right? So they both made these motions, these filings, arguing their perspective on this issue. And both of them are understandable. They're both reasonable. They're both well argued. They have they make sense. They're not outlandish at all. And the judge's job is to take both sides, consider them, cut through the advocacy that each side is making in the way that they're contouring their arguments to make sure it makes their case best, right? As they would. Makes total sense. That's what you would want your attorney to do for you in a similar situation. You'd want them to contour their argument to make it the best for what your side needs it to be, for you to win, win the argument in the law, in the court. But the judge's ruling here, on page 17 of it, has cut through the advocacy that each side made and has made plain sense of the statute, the history, and the appointment of Halligan. And there's just no need to have such a, I'm sorry, I'm going to say it. There's no need to have such low IQ reactionary responses. Really, it's unreasonable and it's low IQ to just flippantly dismiss this as BS or deep state judge or whatever. It's just, those are low IQ takes. And we should be better than that. And when we read this, or when you listen to me read it, I hope it strikes you as perfectly reasonable and understandable. And also, it's the court system working the way it should. It's the judicial branch working the way it should. If you were a defendant in this case and the attorney prosecuting you, there was something unlawful about the way that they came into that position, you would be doing the exact same thing. You would want your attorney to make this same argument. And if this order came down, you would then celebrate it as justice, wouldn't you? And I think that whether you think Comey is guilty here or not, I hope you agree that the way we prosecute him matters. The steps that are taken, the way that process of prosecution is carried out, the way the investigation was carried out before then, which there are regularities with that, it matters. It doesn't just matter what you do, it matters how you do it, particularly when it comes to justice. And when some step in that process is incorrect, is violative of someone's rights, or violative of the statute or statutes at issue, violative of the way the system is supposed to work, it must be corrected. And it being corrected is also justice. It's correcting for justice. So to me, even though I want the case to go forward, I would much rather Halligan have been lawfully appointed, or at least some other prosecutor have signed on to this so that the case could go forward. That would be my wish, because I think that we're not there yet on proving Comey's guilt. I want to see the case go forward because I'm super interested in it. It's an interesting case. It has opportunities for all sorts of disclosure. And the prosecutors initially had said there was classified material that they wanted to declassify. So I want more documents and I want more transparency on the whole thing. If I could wave a magic wand and reset things and set them up in the right way, I would. With Halligan or whoever being lawfully appointed, a prosecutor signing on to this, the case going to trial, us getting a trial, finding out exactly, letting a jury determine whether Comey is guilty of the charges or not. And I would love that. In other words, I would, if I could make it so, I would make it begin in the right way. But it is very obviously not right. It's not right how Halligan was appointed. It's not right how the investigation didn't separate a bunch of attorney-client privilege material and use a filter team before they brought the charges. It's not right that apparently the investigators went over the scope of the search warrants and got more material than they should have. It's not right that Comey's Fourth, Fifth, and Sixth Amendment rights appear to have been violated during the investigation in the lead up to the charge. It's not right, all the irregularities, which are numerous, that occurred with the grand jury. There's so many things about this that are not correct. And every time we pursue justice, it's important that every step is correct and ethical, that I's are dotted, T's are crossed, and it's done the right way. If justice matters, then so does the way we go about attaining it or exacting it. Everybody knows this. You teach your kids this, don't you? Don't you teach your kids it doesn't matter how you win, it matters how you play the game? Because that says something about you as a person. That's how you maintain your integrity. It's similar to this. So, there's my little speech at the end of that section. Okay. Next part. Halligan's appointment also violated the Appointments Clause. As discussed, the Appointments Clause allows Congress by law to vest the appointment of inferior officers in the president alone, in the courts of law, or in the heads of departments. Through Section 546, Congress devised a statutory scheme that vests the appointment of interim U.S. attorneys first in the head of a department and then in the courts of law. Because Ms. Halligan was appointed in violation of that scheme, her appointment was not authorized by law and thus also violates the Appointments Clause. Resisting this conclusion, the government briefly asserts that not every action in excess of statutory authority is ipso facto in violation of the Constitution. That is true, but besides the point. An officer cannot lawfully exercise the statutory power of her office at all unless she has been properly appointed. And here, Ms. Halligan has not been appointed, 1, by the president with the advice and consent of the Senate, or 2, through a process Congress has authorized by statute. So an Appointments Clause violation has occurred. The next question is what to do about that violation. Dismissal of the indictment is what's appropriate. The Appointments Clause is more than a matter of etiquette or protocol. It is among the significant structural safeguards of the constitutional scheme. The clause not only serves as a bulwark against one branch aggrandizing its power at the expense of another, but also preserves another aspect of the Constitution's structural integrity by preventing the diffusion of the appointment power. Given its importance within our Constitution structure, remedies with bite should be applied to appointments that run afoul of the clause's restrictions. Here, Mr. Comey contends Ms. Halligan's unlawful appointment renders all her purported official actions void ab initio. He therefore argues the case must be dismissed because Ms. Halligan was not lawfully exercising executive power when she appeared before the grand jury alone and obtained his indictment. I agree. And I agree. When an appointment violates the Appointment Clause from the jump, the actor has exercised power that she did not lawfully possess. By the way, this United States v. Giraud case, is the one that challenged Alina Habba's appointment as interim U.S. attorney and challenged it successfully. And this judge has quoted it several times in this case. Okay. In such a case, the proper remedy is invalidation of the ultra-vires actions taken by the actor. See United States v. Trump, Southern District of Florida. In other words, Judge Cannon's dismissal of Jack Smith. Invalidation follows directly from the government actor's lack of authority to take the challenged action in the first place. That is, winning the merits of the constitutional challenge is enough. In light of these principles, I conclude that all actions flowing from Ms. Halligan's defective appointment, including securing and signing Mr. Comey's indictment, constitute unlawful exercises of executive power and must be set aside. There is simply no alternative course to cure the unconstitutional problem. Again, that's a quote from Judge Cannon's order dismissing Jack Smith. The government attempts to counter this result with several arguments, but none is persuasive. First, the government argues that whatever her status as U.S. attorney, Ms. Halligan still validly obtained and signed Mr. Comey's indictment as an attorney for the government. In support of this argument, the government relies on the Attorney General's October 31st order, which would have to be retroactive, which purported to retroactively appoint Ms. Halligan to the additional position of special attorney, effective September 22nd, 2025. I shouldn't shake my head and make it seem like that's a absurd title. It's a real title. 3 days after Comey was indicted, or 3 days before. Although the Attorney General has the power to appoint subordinate officers to assist her in the discharge of her duties, the government has identified no authority allowing the Attorney General to reach back in time and rewrite the terms of a past appointment. And can't we all agree that that just sounds absurd? No. The Attorney General can't retroactively empower someone. Can't retroactively, after the fact, delegate executive authority to a person. Delegate to someone retroactively the power to imprison that person. That's what we're talking about here. Absurd. It's absurd. Nor can the variation between September 22nd and October 31st orders be dismissed as mere paperwork error, as the government suggested. The September 22 order was unambiguous. The Attorney General stated she was appointing Ms. Halligan under 28 U.S.C. 546 to, quote, serve as the United States Attorney for the Eastern District of Virginia for the period of 120 days or until replaced in accordance with law, whichever occurs first. The October 31st order then purported to appoint Ms. Halligan to an entirely different position, special attorney, under entirely different statutes, 28 U.S.C. 509, 510, and 515. I reject the Attorney General's attempt to retroactively confer special attorney status on Ms. Halligan. Regardless of what the Attorney General intended or could have done, the fact remains that Ms. Halligan was not an authorized attorney by law to conduct she was not an attorney authorized by law, period. Let alone one authorized to conduct a grand jury proceeding when she secured Mr. Comey's indictment. Second, the government contends that even if Ms. Halligan lacked the authority to obtain and sign indictments when she appeared before the grand jury, her actions should be entitled to de facto validity. When applicable, the de facto officer doctrine confers validity upon acts performed by a person acting under the color of official title, even though it is later discovered that the legality of the person's appointment or election to the office is deficient. In other words, the doctrine operates so that a defect in an official's appointment is not inadequate ground to challenge his earlier decisions. But the de facto officer doctrine applies only to some non-constitutional appointment challenges. It has no application when appointments clause challenges are involved. Completely different thing. In Ryder, a different case, A unanimous Supreme Court declined to apply the de facto officer doctrine to a claim that 2 judges on a panel of the Coast Guard Court of Military Review had been appointed in violation of the Appointments Clause. The court held that, quote, one who makes a timely challenge to the constitutional validity of an appointment of an officer is entitled to a decision on the merits of the question and whatever relief may be appropriate if a violation indeed occurred. Any other rule, it explained, would create a disincentive to raise Appointment Clause challenges with respect to questionable appointments. The court then buried past precedents applying the doctrine. It declared, to the extent those cases may be thought to have implicitly applied a form of de facto officer doctrine, we are not inclined to extend them beyond their facts. After that case, called Ryder, the Supreme Court in Lucia, a different case, doubled down on its holding that the de facto officer doctrine has no place when Appointments Clause challenges are involved. Given the court's holdings in those 2 cases, Ryder and Lucia, the de facto officer doctrine does not bar the relief sought by Mr. Comey. Third, the government submits the grand jury's independent decision to indict Mr. Comey renders any error in the indictments harmless. The customary harmless error inquiry is normally applicable where a court is asked to dismiss an indictment prior to the conclusion of the trial. Harmless error analysis does not apply, however, when the structural protections of the grand jury have been so compromised as to render the proceedings fundamentally unfair. This case presents the unique, if not unprecedented, situation where an unconstitutionally appointed prosecutor, exercising power she did not lawfully possess, acted alone in conducting a grand jury proceeding and securing an indictment. In light of the near complete control that prosecutors wield over the grand jury process, such an error necessarily affects the entire framework within which the proceedings occur, and thus defies analysis by harmless error standards. Comey's going to sue and win some money, guys. I don't know if you guys have figured that out yet, but that's going to happen. Comey is going to sue the DOJ, and he's going to win. He's going to sue the DOJ, and he's going to get back all of his expenses for the attorneys. He's going to get back money for time and inconvenience and defamation of character. You better believe it. If the government indicts you and the person who indicted you never had the authority to do so, and there's all of these problems with the case the government brought against you, aren't you going to sue? And wouldn't it be correct to get compensation? Watch it happen. As a final fallback position, the government argues that even if Mr. Comey's indictment is flawed, dismissal is inappropriate because the Attorney General has since ratified Ms. Halligan's actions before the grand jury and her signature on the indictment. Even assuming the agency law doctrine of ratification can be used to cure a defective indictment, and the government cites no authority holding as such, the Attorney General's attempt at ratification of this indictment fails. Ratification is the affirmative or the affirmance by a person of a prior act which did not bind him but which has done or professedly done on his account. In effect, the doctrine reaches back and makes it so that a formerly unauthorized act was authorized from the get-go. But for ratification to be effective, the principal must have had the authority to authorize the action both when the action was initially performed by the agent and when the act was affirmed and thereby ratified by the principal. The Attorney General lacked that authority at both points here. I have already concluded that Ms. Halligan's original appointment was invalid, and that the Attorney General's attempt to retroactively bestow special attorney status on her was ineffective. As a result, the Attorney General could not have authorized Ms. Halligan, who was not an attorney for the government at the time, to present Mr. Comey's indictment to the grand jury on September 25th. The implications of a contrary conclusion are extraordinary. It would mean that the government could send any private citizen off the street, attorney or not, into the grand jury room to secure an indictment so long as the attorney general gives her approval after the fact. That cannot be the law. It's almost like it offends just, doesn't it offend your intelligence that that's something that Bondi tried? And I actually think Bondi's been doing a great job as AG. But the idea that she could retroactively empower Halligan to do a bunch of things in the past, and then she could retroactively ratify an indictment. I mean, it's not just extraordinary. It's intellectually offensive. It blows my mind. And this is what it would mean. The judge is right. As I was saying before, like, you can't retroactively authorize someone to conduct a proceeding that could end you up in jail. It would mean that I could go and kidnap someone and then hold them hostage and then like accuse them of a bunch of crimes and then sentence them or bring them to court or something. And then the AG could come in after the fact and say, actually, Just Human was authorized by these statutes. I retroactively appoint him a prosecutor for Western District of Virginia. In all those ways that he violated that person's rights, pretending he was a prosecutor in the Western District of Virginia, well, they're not actually violations because I retroactively cure them. Yeah. I feel like I need that Geico commercial. That's not how any of this works. And it's definitely not how any of it can work. The government also fails to meet the second requirement for a valid ratification, that the principal must have been able to do, the principal here would be Halligan, must have been able to do the act ratified at the time the ratification was made. And she couldn't. I mean, it's so silly. Similarly here, the Attorney General's attempt to ratify Mr. Comey's indictment on October 31st came too late in the day to be effective, as the statute of limitations for the charged offenses expired 31 days earlier, this is why this case can't be refiled. The indictment that was so if you bring an indictment and the statute of limitations, while the person is under indictment, the statute of limitations runs out, okay? But the person is already charged. But then something about the charge ends up getting it thrown out for whatever reason. But it's without prejudice. There's a time limit where, I think it's 6 months, where you can bring that charge again, because you can basically say, we had a case, there's like a grace period. There's a grace period where the government could bring the case again. But here, I'm just going to let her explain it. I didn't realize she was going to get into it. The government responds that the Attorney General's ratification was proper because she could have personally obtained a new indictment on October 31st using the grace period set forth in 18 U.S.C. 3288. The statute provides in part, whenever an indictment or information charging a felony is dismissed for any reason after the period prescribed by the applicable statute of limitations has expired, a new indictment may be returned in the appropriate jurisdiction within 6 calendar months of the date of the dismissal of the indictment or information. By its own terms, Section 3288 only applies where an indictment has previously been dismissed. But on October 31st, Mr. Comey's indictment remained pending. Thus, the Attorney General could not invoke Section 3288 at the time the ratification was made. And the clock doesn't reset. Dismissal without prejudice. Having found that Ms. Halligan's appointment violated 28 U.S.C. 546 and the Appointments Clause, and that dismissal of Mr. Comey's indictment was warranted, The remaining issue is whether dismissal should be with or without prejudice. Relying primarily on the Ninth Circuit's decision in United States v. Bundy, Mr. Comey urges me to exercise my supervisory powers and dismiss his indictment with prejudice. A with prejudice dismissal is necessary, he argues, to vindicate the interest protected by the Appointments Clause and to deter the government from using unlawful appointments to effectuate retaliation against perceived political opponents. The government, on the other hand, asserts that any dismissal should be without prejudice, for Mr. Comey comes nowhere close to showing flagrant misbehavior, substantial prejudice, or the unavailability of a lesser action, as required by Bundy, a different case that is a precedent here. Ultimately, I believe the Supreme Court's Appointments Clause jurisprudence provides the answer to the with or without prejudice question. In both Ryder and Lucia, the court essentially unwound the actions taken by the unconstitutionally appointed officer and restored the affected party to the position the party occupied before being subjected to those invalid acts. I will do the same here. I will invalidate the ultra vires acts performed by Ms. Halligan and dismiss the indictment without prejudice, returning Mr. Comey to the status he occupied before being indicted. Conclusion. For the reasons set forth above, it is hereby ordered and adjudged the appointment of Ms. Halligan as interim U.S. Attorney. Her appointment violated 28 U.S.C. 546 and the Appointments Clause of the U.S. Constitution. That's number one. Number two, all actions flowing from Ms. Halligan's defective appointment, including securing and signing Mr. Comey's indictment, were unlawful exercises of executive power and are hereby set aside. 3. The Attorney General's attempts to ratify Ms. Halligan's actions were ineffective and are hereby set aside. 4. Mr. Comey's motion to dismiss the indictment is granted in accordance with this order. 5. The indictment is dismissed without prejudice. 6. The power to appoint an interim U.S. Attorney for the Eastern District of Virginia pursuant to 28 U.S.C. 546 during the current vacancy lies with the district court until a U.S. Attorney is nominated by the President and confirmed by the Senate under 28 U.S.C. 541. Signed, Senior United States District Judge Cameron McGowan Currie. And I think that makes perfect sense. Let me know what you guys think. I would appreciate your feedback. You can visit my link tree in the description of the show or in my profile for all the places to follow, all the places to watch, all the places to listen to the content I make. And you can find links to support the show. There's some affiliate links, Mints and Honey Farms, bootleg products, Manly Cans if you want to buy something for yourself or somebody else. If you use my affiliate links, they'll kick a few dollars my way. Ko-fi.com if you want to keep me caffeinated. And justhuman.substack.com if you want to keep me caffeinated and contribute a few bucks to my Pacer account. I have a very serious Pacer habit and a coffee addiction. Those things ain't cheap. So thank you to everybody who supports and who listens, who likes, shares, and comments. Thank you very much. Y'all have an awesome Thanksgiving, and I will see you in the next video.